So let me move on to the proper event and introduce Dr. Sam Da Silva, CITP BCS. He's a partner and technology and in the technology and outsourcing practice at the largest law firm in Europe, CMS, it says. He's also a trustee of BCS and a BCS council member, specializing in complex and strategic technology and outsourcing projects. He's got a vast list of credentials, achievements, and acclamations. I won't begin to try and read that out because that will take the rest of the evening. And many of those are to do with his voluntary work, helping develop understanding and taking forwards many of the key concerns in terms of his take on the legal aspects of the profession. So it says here, he makes it his mission to dispel myths and educate IT professionals to ensure everyone is on the same page, which is what we're going to do now. So Sam, after that very wordy introduction, I'm going to take a break and leave it all to you. Thank you very much.
Great. Thanks, Simon. Firstly, thanks to Simon and Alan for inviting me to speak at this BCS consulting specialist group. I always enjoy coming and, well, virtually, obviously now speaking to different consulting, different various specialist groups. It's always good to see a diverse audience and different interests and so forth. So without further ado, I will attempt to share my screen. Can you see my screen? Yep, okay, excellent. So as advertised, we're going to be talking some of the contractual issues in consulting engagement. So what am I going to cover today? Hope you don't fall over. I know it's a packed agenda, but I will take it through. I'm obviously conscious that I've got limited time, so we won't be here all till midnight. So yeah, it will be a helicopter view, but hopefully we'll cover the things we need to cover. So I'll set the scene, give a bit of context, then we'll probably cover the big three first, probably the more complex and more convoluted areas where people sort of get confused, not really understand what's going on. Sometimes they do, sometimes they don't. Try to dispel some myths. So I'll talk about liability, talk about indemnities, and talk about intellectual property. I call those the big three. Then we'll look at sort of scope of work, change control, acceptance testing, remedies for delay, termination, protections for the consultant, and end off with that exciting area of data protection. Now, I obviously advise on this, but I'm not what I would say a data protection specialist who does this 100% of the time. There are some people who do this 100% of the time. I probably do about 25–30% of the time. And fortunately, I've got a lot of data protection specialists who do 100% of the time, so I can actually delegate and refer to them. But clearly, I need to do some work on this, so that's what I'm going to talk about in the context of consulting arrangements. Sorry, so setting the scene. So as advertised, this session is really focused on SME and large consulting firms. So if you're an independent sort of contractor or working through a sort of a company, you may find some of the stuff useful, insightful. There will be relevant nuggets, but it's mostly relevant for those of you who are employed or a partner or a director in a, as I said, in a consulting firm. In terms of terminology, there's a lot of terminology here. This consulting agreement, terms of engagement, engagement letter, T's and C's. What do they all mean? Well, effectively, they're the same thing. You know, there's no real rocket science of how these things actually mean. They're an arrangement between the consultant firm and the customer, and you can call it what you want. I mean, you could call it, you know, apples and oranges. You know, there's no sort of, I guess, formula or standardization for naming these things. No naming convention. So whenever we talk about this, we mean the arrangement between the between the consultant and the customer. The other sort of terminology we sort of probably see in these sort of arrangements is what we call a consulting proposal. Now, this is really the thing which is done before the contract, i.e. your sales presentation, your proposal to effectively go to the customer and say, this is what I can do as a consultant. So that's what we call the consulting proposal. Now, some of the other things we need to think about, whose form of contract should be used, i.e. is it the consulting firm contract or is the client or customer contract? Now, there's no rules or I guess standards relating to this. It really depends on a number of things. First thing it depends on is the negotiating leverage. If you're a particularly large consultant, you can impose your terms, or it may well be if you're providing a particular type of service which is quite bespoke and you say this is the reason why we need to use my form of contract. Obviously customers and clients will want to impose their contract on yourself as a consulting firm. So you need to, I guess that's the first thing you need to, agree whose form of contract should be used. Now, one thing you need to be aware of, obviously, if you use the customer's contract or the client's contract, that will be very one-sided, focused on their interests. So you will have a lot of work that you need to basically review and negotiate and revise to make that a more balanced contract. Obviously, if you're using your contract, it will be most focused on you. You'll be protecting the consultancy's interests. So that was what going in position is, if you can, I would recommend using your form of contract. Now, use of templates. Now, you can get a variety of templates off the internet. Cut and paste. We won't talk about breaching copyright, but there are a variety of templates available, some free, some you have to pay for. The thing I'll say about templates is you need to make sure it is actually tailored to the engagement. Otherwise, it may look like it does the job, but unless you actually understand what the provisions are there for, and actually it relates to the type of service you're providing, templates can be quite dangerous. So you need to make sure, obviously you can prepare a document and then that could be the template going forward, but it's basically, how do you get that first form of document there? What do you need to do? And my recommendation is to get a bespoke drafted contract for your particular engagement. Now, a misconception is people think agreements need to be in writing or a specified form. That is a bit of a myth. You don't need an agreement to be in writing. So you may well have an agreement orally agreed, and that will be legally binding. So, don't think just because you haven't got an agreement which is signed, you actually haven't got a legally binding agreement. You may well have an agreement, it's not signed, but you perform services, and the client customer pays, you will have a binding agreement. The courts will interpret that as agreement which was unsigned. So the signature just is proof that there is some kind of agreement of the minds, but it's not necessarily indicative of an agreement. So what that means is, unfortunately, you may get into a situation where you make inadvertent variations to the agreement through sort of emails or by sort of talking to the client. So you need to make sure that all of those are documented, because even if they're not actually documented and you actually say something in an email or a telephone call, that will be technically legally binding, and that will inadvertently vary the agreement you've bound. So you need to be careful of those inadvertent variations. The other thing is pre-contractual liability. So you may agree a consulting agreement with a client which limits your liability, excludes your liability appropriately. We'll talk about liabilities in the next slide, but that won't sort of save you from pre-contractual liability. So say, for example, I'm sure none of you would do this, being professional consultants, you are, make some kind of misrepresentation. It doesn't need to be fraudulent, it just needs to be a misrepresentation. Now, the liability limits and exclusions in the contract won't save you from those misrepresentations. So that's pre-contractual liability, which can't be excluded if you make a misrepresentation, and that's the law. So you just need to make sure that effectively you don't tell porkies, because you will be held to account. That's obviously a technical term, don't tell porkies, and write that down, but don't put that on the contract, because the judge will probably look at you thinking, who actually told you to write this down? That's just setting the scene. So now we'll talk about liability. So what is the position when silent? So what I mean is, you've got a consulting agreement and it has no clauses or provisions dealing with liability. Now, I would usually ask the audience to participate, but given that you're all muted and can't speak, it's going to be quite hard to get interaction. Or can we get interaction, Simon?
I'm sure we can get some interaction. Let me just check who's... Can you guys unmute yourselves? Does that work?
Yes, it works.
Okay.
I'm unmuted.
It works.
You've got some willing voices there, Sam.
Okay. So what is the position when it's silent for liability, when nothing's mentioned about liability?
Up to interpretation?
Not
Well,
exactly.
There must be statutory liabilities that come into play if nothing's mentioned anyway.
Yep.
In my opinion, you've got unlimited liability if nothing's been said about liability.
Exactly, Simon. Very well. And we didn't rehearse this either. So yes. So just because liability is not mentioned, you as a consultant will have unlimited liability to the customer and vice versa. So clearly that is a position you don't want to be in. You don't want to be a position where you have unlimited liability, and that's why limitations of liability and exclusions of liability are really important. And there's a distinction here as well. So people think about limitation of liability, exclusions of liability, it's the same thing. They're two different concepts. So limitation of liability is actually you're limiting your liability to a particular amount. Whereas an exclusion of liabilities, you're excluding certain categories of losses. So a limitation on liability would be the consultant is liable for 100% of the consulting fees. That's a limitation on liability. An exclusion of liability would say the consultant excludes liability for loss of income or indirect losses or any other losses you exclude. So that is a distinction between a limitation and exclusion. And in your consulting agreement, you should have both a limitation and an exclusion. Now, there's certain categories of losses which can't be excluded by law. And if you try to do that, you will be frowned upon by law, by the judges. But, that's why usually you see a clause saying, the parties won't try to exclude liability, which can't be excluded by law. So the three types which can't be excluded is death or personal injury caused by negligence, misrepresentation, and then there's the breach of terms implied by law. So the two sort of terms implied by law are warranties as to title and quiet possession, which is under Supply of Goods and Services Act, and the warranties as to the quality of the goods under the Sale of Goods Act as amended by Supply of Goods Act 1994. Now you may think, well, why is Sam talking about this? We're not producing any goods, we're consultants. We're all about the thought leadership. We're all about the services. But the issue here is if you're delivering some kind of software or some kind of thing which is not a good, sometimes is characterized as a good. So there's a lot of debate whether software is a goods or service, and there's no sort of tested answer by the courts. There's various court decisions which have held software is a good. There's other court decisions which have held that software is a service. So that's why it's quite important to realize that there are these terms which may be implied, which may be relevant for the service that you're providing because they're held to be a good. So just something to be aware of. Now, one of the things you need to consider is, setting a liability cap. So, the usual market practice is setting the liability cap to your consultancy fees. Now, I think most people accept that, but there's ways to sort of slice and dice that. You know, as a consultant or a service provider, what you want to do is basically try to minimize your liability. So what are some ways to do this? So you may set the liability cap to, you know, not 100% of the consulting fees, or, you know, you could set it to 50% of the consulting fees, but the customers and clients will be quite cautious about that. You know, that's sort of like a red flag to a bull. So some other ways to slice and dice it, say, okay, we'll set the liability cap to, you know, 100% of the consulting fee over a 12-month period. So your consulting engagement may go for 3 years, 5 years, but you're limiting your liability for an annual amount. Another way to sort of limit and exclude your limit your liability is to limit your liability to the consulting fees paid. So there's a lot of difference between paid and payable. So if you sorry, if you limited your liability to the consulting fees and you remained silent whether it's paid or payable, your liability would be interpreted as the amounts that are owing to you. So by saying it's paid, you'll actually lower your liability, which is more favorable to you as a consultant. So it's always better to limit your liability to 100% of the consulting fees, which is paid, rather than payable. Indirect and consequential losses. So this is a concept which, you know, at law exists. So there's direct losses and there's indirect and consequential losses. So effectively, direct losses are losses which flow directly from the breach. Indirect losses are losses which are one step removed. Now, I'll give you an example. So you're providing consulting services. You don't perform it in accordance with the contract. An indirect loss which the client may have suffered is effectively they've paid you for those services, but they haven't got what they thought they were. So that would be a direct loss. The direct loss would be the amounts that they've paid you as a consulting service. Now, an indirect loss, that would be one step removed. So that could be arguably, they could say, well, you didn't perform our services, you didn't perform your services, and because you didn't perform your services, we weren't able to achieve this business outcome, and we've lost this particular contract, we've lost this particular business. So those are indirect and consequential losses. So those are one step removed. So as a consultant, you want to make sure you manage your risk. So it's always good to exclude indirect and consequential losses, because those are things which are outside your control and you can't really manage it. Whereas direct losses, you can control and manage. And if you're trying to exclude direct losses, your client's going to look at you and say, well, you know, why are you excluding that? It's very difficult to actually try to argue that you're going to exclude direct losses. Now, the devil is in the detail. So what I mean by this is, there's an example in the next slide. There's two examples here of a exclusion clause. So anyone want to provide the observations of what the difference is and what the consequence is?
Well, in the first, the consequential losses looks like it's including a lot of other things. But in the second, sorry, that's the second. But in the first, the other things stand alone aside from consequential losses.
Correct. Is that you, Stephen?
Yeah.
Yeah, exactly right. So example 2 is actually narrower, and it's actually better for the consultant because of the word including. How a court would interpret that is basically they would sort of import the words indirect loss of profit, indirect loss of revenue, indirect loss of business. So in that example 2, it will be the consultant excludes indirect losses, consequential losses, including indirect loss of profit, indirect loss of revenue. Sorry, that is actually wider, sorry. So example 2 is actually worse off for a consultant because the customer or client could actually sue you for direct loss of profit and direct loss of revenue. So you only have excluded indirect loss of profit and indirect loss of revenue in example 2. Whereas example 1 is much more favorable to a consultant because of that, because there's no word including in there. They've excluded indirect losses and consequential losses, and loss of profit, loss of revenue has been excluded, and it's both direct loss of profit and indirect loss of profit which has been excluded. So it's much wider. So that is example 1 is a better exclusion of liability clause than example 2.
Sam, I would think that when anyone putting including would also say, as a matter of form, including but not limited to as well, because it's showing these are only just examples, so even widening it even further.
Yeah, and yeah, although sometimes you don't need that without limitation. You got on your interpretation clause at the start of the clause, the start of the agreement, you've got that clause saying, any words which have the word including is deemed to be without limitation. So it'll be interpreted as without limitation.
Okay, that's covered in the definitions of what included means.
Yeah, in the interpretation.
It all depends what means, doesn't it?
Yeah. So as I said, the devil is in the detail. So you can see that word including there has quite a lot of ramifications in terms of exclusion of liability. So going back to liability, so liability provisions and interplay with insurance. So this is one thing that consultants often get sort of a bit confused with. So they think we've got professional indemnity insurance of X million pounds. We can limit our liability to that. I think that is a very dangerous approach, because just because you've got insurance doesn't mean the insurance will pay out. So you shouldn't limit your liability to the amounts of insurance you have. It's fine having a different clause saying you have insurance of X million pounds, a standalone obligation, because that is a contractual obligation, and you will fulfill that contractual obligation by having the insurance policy, but you shouldn't link the liability to the insurance amounts, because otherwise you'll be caught short in most cases. So you want to limit your liability to a specified amount rather than linking it to the insurance because of that potential shortfall. So we talked about sort of the devil is in the detail here. And I'm talking about also the Unfair Contracts Act, Terms Act 1977. So this, or ACTA. So what this is, basically, this is a piece of legislation, and it's not applicable just for consumers. It is applicable for business to business contracts. What it says, that effectively what it says is, if you've got a contract and you're dealing with two parties of equal bargaining power, and you're dealing on a sort of a standard form contract, i.e. the consultant's contract in this case, if a clause is so unreasonable, it will be held to be unenforceable. So the danger for a consultant is you have a really unreasonable liability clause. So you exclude basically pretty much all liability. You're not taking on any liability. So what ACTA would do is, if that contract ever came to court, if the customer sued you because they said, look, this clause is unreasonable, they could argue ACTA, and a judge could say, okay, that clause is unreasonable, therefore you've got potentially unlimited liability. We effectively strike out your limitation on liability clause. So what that means is you need to make sure that you protect your interests, but at the same time, it is consistent with market practice, and it's also, I guess, protects your interests as well as trying to protect the customer's interests to the extent possible. It's not so one-sided that it means that it's held to be unfair under ACTA. So that's one thing you need to bear in mind to make sure that you don't fall foul of ACTA.
Can I just ask a quick question?
Yeah, sure.
Is it possible for the parties to put in the contract that they will not apply the Unfair Contract Terms Act? Can you not do that?
Yeah, you can pull that, but you can put that in, but it'll be held to be unenforceable, because you often see wording in contracts saying the parties are of equal bargaining power, they've negotiated this clause and trying to circumvent it. But yeah, a judge will see through that. So that those kind of clauses are probably not worth the writing in the ink, or the amount of money you paid the lawyer to put that in.
Okay, thanks.
Excuse me. So indemnities. Now, this is a concept which many people don't understand, and they think it's similar to a liability. It's not. It's quite different. So the easiest way to think of an indemnity is thinking of it as like an insurance policy. So effectively, if you provide it as a consultant, you provide an indemnity, you're effectively underwriting the risk and providing a form of insurance to the client. So let's imagine the situation without indemnity. So you don't have any indemnities which you're providing to the client. You just have a limitation on liability or exclusion of liability. So in order for the client or the customer to sue you, what they would need to do, they have to prove their loss. They have to take steps to mitigate the loss. Even if they've done that, they may not be able to recover all the ancillary costs and expenses. What I mean by ancillary costs or expenses are court costs, solicitor costs, expert costs, or professional legal fees, and all the other the costs which are incurred as part of a litigation. And clearly, you need to show, the client needs to show that the loss had been caused as a result of the breach by the consultant. So that's the situation without an indemnity. So it is quite difficult for a counterparty to actually sue you. It is obviously possible, but it is not an easy thing for them to actually sue you and get damages. But with an indemnity, it makes it much easier for them to claim money, because effectively it's a promise by the consultant who's providing the indemnity to basically reimburse you for a particular liability, and it's guaranteed remedy. It's a pound for pound. So if the indemnity was like £1 million and the trigger was actually let's say the indemnity is for an IPR infringement, and there was an IP infringement, you would have to pay £1 million. It is effectively as stated in the contract, and it also allows recovery for costs and expenses. So as well as being liable for the actual damages or loss, you'll also be liable for the other expenses, i.e. the solicitor fees of the other side, the experts of the other side, and so forth. So that is why I say it's considered very carefully prior to committing any indemnity, prior to giving any indemnity. So, you are basically providing an insurance policy over and above your liability, exclusion, or liability. So whenever you give an indemnity, think about it really carefully and think, are you really prepared to give that? And I guess, you want to try to push back on that and say, what to the client, what are you trying to address? Why do you want me to provide this indemnity? What is the risk you're trying to address? And then you need to try to come up with a solution as to that. Obviously, you can limit your indemnities. You can make it subject to a limitation liability clause, but if you do, you need to expressly say that that particular indemnity is subject to that limitation or exclusion of liability, or otherwise it'll be held to be unlimited. So intellectual property or IP, that again, like indemnities and liability, IP is a very emotive subject. People get quite sort of emotive, and there's a lot of debate and negotiation on this. But in terms of a consulting arrangement, what do we mean by IP? People just say IP. I want to own the IP. This is all about the IP. Okay, what are we talking about? IP as a term doesn't mean anything. There are sub sort of categories of IP which have particular sort of meaning. So in a consulting arrangement, the main types of IP which are relevant is copyright. So there'll be copyright in the words you write in a report, copyright in any code you develop. So that's effectively one particular form of IP, and it doesn't need to be registered. It exists on creation. Patents, obviously, is to protect sort of expression of ideas. And it is quite a high threshold for something to be patentable, but that is IP right. The other sort of IP right that's relevant in sort of consulting agreements is probably database right. So if you spend a lot of time and effort putting together a database would exist. So those are the main types of IP which are relevant, and that should be defined and categorized in your consulting arrangement rather than just referring to IP. Now, people often talk about know-how, yeah? As consultants go, we've got a lot of know-how, we've gleaned all this experience, we want to protect it. Well, know-how is not a form of IP. So, you know, how you protect know-how is through contractual protections, i.e. confidentiality provisions. So usually the IP provisions wouldn't protect know-how. And if you try to put know-how into confidentiality, it doesn't, into the definition of, sorry, IP, it doesn't really work. So it's a separate sort of area. It's not IP. It's basically, you know, you need to have contractual obligations or restrictions on people using your know-how. So it's, as I said, it's covered in the confidentiality clause. Now, when you're looking at IP, I think that the key questions that the consulting engagement needs to answer is, you know, what is the IP owned by the consultant? You know, what is the IP owned by the client? You know, what IP is retained by the client after consultants delivered the service? What license terms apply to any IP that the consultant sort of transfers the license to the client, and what IP will be returned or destroyed on project completion. So your consulting agreement needs to cover all those, answer those questions. If it doesn't, you've got quite a bit of work to do. If it does, then you've probably covered about 80% of the issues about IP. Now we're sort of covering other things in the consulting agreement. So scope of work services. Now this is pretty fundamental to a consulting agreement. This is, you know, what you're delivering. So some of the problem areas I've sort of seen when advising both consultants and clients is basically a cut and paste of the consulting proposal. So I mentioned the consulting proposal is, you know, your presentation, your pitch document. Often I see that cut and paste and put that into a service description of the scope of work. And basically that's it, saying the services are the consulting proposal. The problem with that is the consulting proposal hasn't been drafted in a way to be contractually enforceable or in sort of to be incorporated in a contract, because that wasn't the intention of the consulting proposal. So the problems that stem from that is, you know, they're open-ended obligations. They're not sort of constrained or restricted. They're not drafted to be contractually enforceable. So i.e., you know, if there's a dispute, it's very hard to enforce those provisions or the particular thing which is in the consulting proposal. And there's a lack of precision and specificity. So again, a lack of detail in that. And that's not a criticism of the consulting proposal. Consulting proposal is the consulting proposal. I'm not saying that we need to draft consulting proposals to be sort of legally enforceable. What I'm saying is, don't cut and paste your consulting proposal into the engagement. What you need to do is look at the consulting proposal and then basically translate that so it is in sort of a contractually enforceable language. It doesn't have open-ended obligations and it's got detail in it. So, you know, in terms of the areas to address, you know, what are the outcomes that the purpose of the consultancy? And they need to be specific and measurable. So, you know, you don't want open-ended or so obligations which you can't measure or actually assess whether it's been performed or not, because this is where the debates and the arguments arise. You know, the client will say, well, you haven't performed, and you will say, yes, you have. But unless you've got clear detail of what you're actually performing or what the standards are, then it's going to be quite hard for you to argue that you've actually achieved what you said you're going to achieve. Include timeframes for the work to be included, to be achieved, including sort of milestones, and define outcomes and service standards. Think about the resources to be allocated to the project. Now, in terms of the resources, often clients and customers will say, we want a key personnel clause. So a key personnel clause, as you know, is saying, you know, Simon Wallace is a key person in this engagement. He can't basically leave for the whole terms of the engagement. He needs to dedicate, you know, 95% of the time, for example. You know, if the client has got enough leverage, they may well be able to sort of argue those clear personnel clauses. But from your perspective as a consulting firm or a consultant, you need to make sure you understand what those commitments are in terms of agreeing to those. Customer requirements. So often these aren't set out very clearly. So these are the things which effectively you as a customer, you as a consultant require the customer to do. So if there's certain things that they need to do in order for you to deliver your services, you need to set those out. And that sort of touches upon dependencies. So they can be used interchangeably. So dependencies are things which, you know, you're dependent on the customer to do in order for you to provide your services. Customer requirements may be dependencies, or they may not be dependencies. You just need them to do that. So they are used interchangeably, but there is a subtle difference. Exclusions. Now, exclusions are effectively, you know, you're providing all these services, but these are the things that you're not doing, i.e. excluded from the scope of the services. So those are the things, again, you need to set out in the scope of work or services. And often when I'm sort of looking at these aren't drafted very well, unfortunately. You know, they're open-ended obligations. There's not many customer requirements. There's no dependencies. You know, it'd be very easy for a customer to say to the consultant, "You haven't performed. We're not paying you," whereas the consultant thinks they have performed. So, you know, it is an important area which which you need as a consultant to get right. So, acceptance testing. Now, if you can get away with this as a consultant, I would try to not have acceptance testing provision, because there's another onerous, well, not another onerous, but it is an obligation on you as a consultant. So what is acceptance testing? So acceptance testing is effectively the process which a customer and the consultant undergoes in order to actually ascertain whether the services which are being performed or delivered actually meets the requirements of the contract. So very favorable sort of provision or schedule for the customer, not so positive for the service provider. But, you know, most sophisticated customers and clients will insist on a form of acceptance testing. So, you know, if they do, you need to make sure it is straightforward and it is not as complex and tiered as when, you know, sometimes it could be. So sometimes customers would say, we want developmental testing, we want user acceptance testing, we want volume stress testing. So at all those levels, there will be a form of testing. And, you know, if a particular thing doesn't pass the acceptance testing, there's various remedies available to the customer. So from a consultant's perspective, what you want to make sure is, you know, you try to minimize the amount of acceptance testing which is done, and you don't have all these different stage testing. Acceptance certificate. So what does it usually trigger? It usually triggers a payment milestone. So it is very important. So obviously, if there is acceptance and an acceptance certificate, you need to be aware of the risk that if acceptance is not achieved, acceptance certificate won't be issued, and therefore you won't get paid that particular milestone. So it does have a fairly important consequence of failed acceptance. Now, what happens if, you know, you can't agree on the results of the acceptance testing? So sometimes acceptance testing is a bit of a tick box exercise. It's binary. You either know the particular thing that you've done is actually passes acceptance or fails acceptance test. So in that case, you know, you don't have to worry too much. But if there's sort of shades of gray or there's some subjectivity that comes to the actual, you know, results of the acceptance testing, what happens if the parties disagree? So you don't want to be in the situation where effectively you as a consultant say, we deliver the services, they pass acceptance testing, the client says, no, they haven't, and then you get, okay, we'll remedy these deficiencies. You remedy it, you say it's passed acceptance testing, the client says, no, it hasn't, and you go backwards and forward. So you want sort of basically to get out of this continuous loop. And one way to do this is to basically say, okay, after a certain amount of period, whether it's a number of weeks or a number of months, or after a particular number of iterations of acceptance testing, then, you know, we need to get to a position that someone actually makes a decision. So, you could refer it to an expert. So an expert comes in and makes a decision, yes, it is past acceptance or it's not past acceptance. So you get a third party coming in. What you want to avoid at that sort of, the remedy, you want to try to limit your remedies. So a customer, a strong customer who's being advised by a strong lawyer who knows what they're talking about, will be telling you as a consultant, will be saying, look, if it doesn't get accepted in a particular time or a particular number of iterations, we want the right to effectively, call an expert, or to basically get a reduction in the charges, or we want the right to terminate. So all those are sort of remedies which are available to the customer. As a consultant, you want to try to limit those remedies, because the more remedies the customer has, the more easier it is for them to actually enforce them, and it's sort of a more challenging for you to actually get paid and get the contract on foot. So we've talked about the consequence of failure to give acceptance. It will give particular remedies to the customer. You want to try to limit that. Now, deemed acceptance. So deemed acceptance is this concept where acceptance isn't actually achieved, so the tests aren't actually carried out, and as a result of the test, you say the services have passed acceptance certificate. It's a situation where you say, in this particular circumstance, it's deemed to be accepted. So obviously, the more circumstances you have as deemed acceptance, the better it is for you as a consultant. So the most common one, which you should insist on, is effectively saying you put the services or the software or whatever that you delivered into live commercial use, client. Even if you haven't done the acceptance testing, if you put that into live commercial use or you're using it, that is deemed to be accepted, and all the consequences that flow from acceptance, i.e. a payment milestone, are triggered. You may also want to say, well, we tell you something's ready for acceptance testing, but if you don't actually do the acceptance testing with X number of days, that's deemed to be accepted. Because you don't want to be in the situation where you as a consultant present something, done your services, delivered the software, so it's ready for acceptance testing, client just, delays and, they don't actually sort of progress. You want to be in the situation where say, no, hang on, we've given you X number of days. If you haven't done it within X number of days, it's deemed to be accepted, and all the consequences that flow from that, i.e. acceptance certificate, payment of a milestone, and so forth. So change control. So, change will happen in these consulting agreements, particularly in these long-term consulting agreements. So what is a change control schedule or change control sort of provision deal with? So the key features is pricing. So you want to know if the customer is requesting a change, what is the impact on pricing? Obviously, as a consultant, you would want the pricing to increase. You don't want to do more services for the same amount. So you need that ability to have actually increase the pricing or the fee. The customer, more astute customers, will say, we, as a result of change control, we want you to do sort of a notification or an impact assessment. I think that's fine, but as a consultant, what you want to make sure is you actually have the ability to charge for it. So you don't want the situation, I've seen sort of consulting agreements where effectively customers have the right to sort of request change controls, and they get this requirement for a notification or impact assessment free of charge. So consultant is going through all these change controls, but then the client says, oh no, we don't want to go ahead with that. And you've done all this work in terms of the impact assessment, and the client just said, no, we don't, it was too expensive, we don't want to go with it. So you want the ability to actually charge for that impact assessment. So you don't want clients to basically ask you to effectively, quote and re-quote and so forth. Flexibility, you also want the ability that the change control mechanism is flexible enough for the arrangement. So, for complex changes, you may want quite a detailed, robust process. For more straightforward changes, you may want more fast-tracked approach. So you may want, 2 processes depending on the type of change. The other thing with change control you need to be sort of, I guess, alert to from a consultant perspective is customers will say there are certain categories of changes which don't attract charges, i.e. they're free of charge. So they may say it's minor technological changes, changes in law, or continuous improvement. Now, obviously you want to try to minimize this list as much as possible. So you don't want to give away, things which are free of charge. You don't want to say, you basically want to charge for everything that goes through change control. Whereas the customer's view is, no, not everything is chargeable. It's a commercial, I guess, debate that needs to be had with your customer, but you need to address it up front when you're looking at actually agreeing the contract. Now, probably the one thing which most consultants get caught out is changes in law. So often the contract is drafted in a way effectively that any changes in law, if there's an impact of a change in law, the consultant actually has to bear the risk. Now, I think in some cases that is unreasonable. I mean, particularly if you're a consultant who is not operating in a particular sector. So, you may be operating across a variety of sectors, and your particular client is a financial services client. They're regulated by the FCA and stuff. There's a change in regulations that means that you need to perform your services in a different way, or you need to deliver something in a way that meets a particular requirement. Now, if the changes in law clause isn't drafted in your favor, what you would have to do is basically deliver that change for no additional cost, but you may be incurring additional resources. You may have to do additional programming. You may need to do additional things, which normally you would be able to change for, but because of this provision, you can't. So you need to be quite careful about these changes in law clauses to see who carries the cost in terms of compliance or in terms of changes in law. Continuous improvement is also another area. There may be some kind of general obligation that you will provide the services in terms of continuous improvement. You don't want the service provider, if the customer, to actually say to you, look, you've got a continuous improvement obligation. Well, even though you're doing these new services, we don't want to pay for it because it's part of your continuous obligation. So as I said, need to be really careful about those changes you agree to which don't attract charges. So change control is effectively an agreement to agree. Now, what an agreement to agree is in simple terms is it's not so an agreement to agree is basically the parties will agree to do something in the future. Now, you could document that in the agreement, yeah, but that is, as a concept, that is not enforceable. So if you have a provision in a contract there, the parties will agree a certain thing in the future, or the parties will agree to do this. If there's not enough certainty, that is an agreement to agree. So change control is effectively agreement to agree. So you can't force another party to agree. Now, customers obviously are acutely aware of this, and that's why they basically make the change control provision in a way which it forces the consultant to implement changes. So there will be clauses there potentially, if you're working on a customer form of consulting agreement, basically says that the consultant can't refuse to agree any changes. So you obviously want to avoid that. If you can't avoid that, you want to have some kind of get out. So the get outs, which are usually I've seen and I recommend to consultants, is effectively saying, okay, if the requirement requires us to breach law, we don't have to do it. If the requirement is outside our skill set or outside our expertise, we don't have to do it. Sometimes it is, okay, if the change requires us to incur X number of man hours or X number of resources to do this thing again, that's a get out. We're not forced to do those changes. So if there's mandatory changes where you're forced to do that, you want a sort of a carve out or get out, or otherwise you'll be forced to do those changes. The other thing which I sort of recommend to both consultants and customers is basically a concept of rationalization or reinstatement of the new baseline contract. So this is particularly important for sort of long-term engagement. So you often have a consulting agreement which is maybe 5-6 years, and you've got a lot of change control notes. You may have 5, 10, 15, 20. I've seen sometimes hundreds of change control notes over a lifespan of 5 years. The problem is, if you have these change control notes, you don't know what the contract actually says. The first change control says, clause X is amended by putting this new clause. Fine, that's okay for one change control. But if there's another change control that amends that amended clause, or it may amend the original clause, just imagine how that problem is multiplied if you have 10 or 15 change control notes. You don't actually know what the provision is. So I always recommend maybe every 6 months or every 12 months that there's a rationalization or reinstatement. So effectively, you look at all the change controls, or you get your in-house lawyers or your external lawyers to actually do all the hard sort of heavy lifting and incorporate all those change control. So you have a new version of the contract which incorporates that. If the customer puts that obligation on you as the consultant, what you need to make sure is say, well, you're prepared to do it and you can also charge for it. Because worst case situation is they put that obligation on you and you haven't got the ability to charge for it, but you're obviously not going to do it because it is quite a torturous process and it can be quite complicated. So you have to sort of incur sort of legal fees and getting external lawyers, or you may get your in-house lawyers, but still there is a cost. So you want the ability to actually charge for that rationalization. So termination. So, often we don't think of termination because, it's often like marriage, who wants to think about divorce? But unfortunately, like marriage, that things sometimes end. So, you do need to think about what happens if things don't go to plan. Now, in terms of the termination triggers for a customer or a client to sort of end the engagement, you need to make sure that the termination triggers are obviously as narrow as possible. So some of the things you need to think about is, have they got a right to terminate for any breach, or is it for a material breach? Obviously, material breach is better for a consultant because that means that there's a concept of materiality, whereas in breach there's not, and it's easier for a customer or client to terminate. What about if a material breach is capable of remedy? If it is capable of remedy, do you want the client to terminate? No. So you need to make sure you build that in, that if it is capable of remedy, they haven't got the right to terminate. Sometimes customers include a concept of deemed material breach. So what this means is they may say, a breach of this particular clause, it may be security or data protection or some other clause, it is deemed to be a material breach. So what that means is it may not have been a material breach or considered a breach which was led to a termination, but because you agreed to be a material breach, then it is a material breach. So obviously you want to try to limit those material breaches or try to remove that concept altogether. And the way that you argue that is say, look, a court will determine whether a particular breach is material or not. We don't want to deem it to be material breach because we're basically, trying to circumvent what the courts will rule in the future. Insolvency. So often customers will say, on insolvency, we want to terminate. I think that's a reasonable argument. There's different forms of insolvency. There's administration, liquidation, receivership. Not going to go into those details, but obviously the wider the list, the more remedies that the customer has. So you want to try to again limit it to sort of narrow circumstances. And sometimes customers say, change of control. So if there's a change of control in the consulting firm, that is a termination trigger. Obviously, as a consultant, you want to try to avoid that. You don't want to give them a termination right if there's a change of control, because you may have sold, the business may have sold, it may have different owners and so forth. And as long as you're performing, you don't want the right for the customer to terminate. Now, those are sort of termination triggers which are at fault, i.e. the consultant is at fault. What about TFC? So what I mean by TFC is a termination for convenience. So this is effectively the ability for a client to effectively terminate where there's no fault. So the first question is, do you want to give the client this TFC right? Again, a commercial debate here, whether you give it or not. Obviously, if you do give it, it's easier for the customer or client to walk away. Now, if you do offer that right, what you need to think about is, what are the costs of them actually? What are the costs you want to recover, or what fees do you want to incur on them imposing that TFC? Because that is an additional right. You're making a concession, so you shouldn't give it free. So what if they have a TFC? What you want to think about is, what about all the demobilization costs? I.e., you may think the engagement is for 5 years, and if they effectively have a right to sort of terminate after a year or 2 years, you may have sort of signed up to long-term commitments in terms of leases, or you may have brought in a number of employees and stuff because you thought it was a big project. You'll obviously still be stuck with those, so you need those demobilization costs to be reimbursed. You may have made sort of unrecovered investment or sunk costs. So you may invested in this relationship because you're assuming it's a long-term relationship, then it gets terminated. So you've got all those sunk costs that you want to try to recover. You obviously clearly want to get payment for your work in progress. So you don't want to be in the situation where you're, charging every 6 months. They basically terminate sort of in month 5, and you haven't obviously charged for it. You've got all this work in progress. So you want the ability to effectively charge for that work in progress. So those are the things you need to think about before agreeing for a termination for convenience sort of right for the customer. Now, linked with termination, you need to think about exit management. So this is effectively the services that are required in order to either for the client to actually do it themselves or bring in another consultant or service provider. So if you're doing exit management, what is the scope of the exit management? How long are you doing it for, and the fees? Are you able to charge for it? Obviously from a consulting perspective, you want the ability to charge for it. You don't want to be in the situation where effectively you have to do a transition or handover to a competitor, or even to the customer in-house, where you haven't got the ability to charge for that exit management or disengagement. So protections for the consultant. So, what are some of the other protections you should build into your consulting agreement? So you should have a section of assumptions. So these are the assumptions that you have based your pricing on, you based your services on. So, you have a section of assumptions. So that's fine. But most consulting agreements have that section, but then it's not clear what happens if those assumptions don't hold true. So you need some wording or some provisions dealing with saying, if these assumptions don't hold true, there is an adjustment to price, or there's a relief from the service standards, or there is some other consequence. You need to make sure that, there is a scenario, you cover the scenario where the assumptions don't hold true. Otherwise, the assumption section is fairly meaningless. Force majeure, this is effectively where things are outside your control and you can't deliver. Obviously, you want the force majeure provision to be as wide and all-encompassing as possible. There's been a lot of debate and an argument recently because of COVID, whether COVID is force majeure, whether it's a pandemic and so forth. So you need to make sure, you try to future-proof and cover as many scenarios as possible in the force majeure clause. Subcontracting. So, do you want the ability to subcontract your services to, another third party? If you do want that, you want to make sure you've got that right to do it. If the customer places restrictions, you want to try to narrow or limit those restrictions. So often they will say you'll have to be liable for the acts and omissions of the subcontractors. That's a pretty hard argument to refute if you're subcontracting. So that's a risk you need to sort of bear. If you do subcontract and the customer will ask you for that, that's pretty hard to push back on it. What that means in practice is you need to make sure your subcontracting arrangement backs to back your main agreement with the client, or otherwise there will be a gap and you will be exposed. The other thing you need to think about is, what about the risk of insolvency of the customer? So ultimately you want to get paid for your service, as a consulting firm or practice. So, if there is a risk of insolvency of the customer, how do you manage that? Well, you can manage that in a number of ways. First one is the payment profile. So you don't want to be in the situation where you build up a lot of work in progress. You get regularly paid, you get paid on milestones and so forth. You may want the right, so if they don't pay in accordance to your payment milestone, you want a right to suspend, because you as a service provider, if you're performing services, you've got a lot of leverage when you don't actually, if you actually suspend your services. That will force, hopefully, the customer to pay. So you need to make sure you've got that express right of suspension to actually impose, to give that leverage for you to, for the customer to pay. You obviously want the right to terminate. So you want to make sure that your rights to terminate as wide as possible. So, you know, payment, not paying in a certain time should be an express right to termination. So when I said before about having deemed material breaches for a customer, try to, you know, resist that. From a consultant perspective, you want to make sure that a failure to pay by a particular day, a particular time period is a deemed material breach. So you have the right to terminate. Now, all those are fine, but it doesn't sort of, I guess, relieve the need to do the due diligence prior to contracting. So prior to contracting, do the due diligence on the customer. You know, what is their financial viability? You know, what are their assets and so forth? Are they able to pay for your services? So do that due diligence before you sign the contract. Other protections for the consultant is, you know, limit. Often customers will ask for audit rights. You want to try to limit those audit rights, whether you limit them to a particular amount of time, you know, X number of days per 12 months, or in the frequency of audit. One way I've sort of found ways to sort of limit audit rights when acting for consultancies is effectively saying, okay, you can audit us, but there will be a cost. You know, every time you audit us, there will be a cost that is imposed. Limit step-in. So step-in is effectively where the customer says you're not performing. They either do the services themselves and basically charge you for that, or they bring in a competitor or another service provider. So again, you don't want step-in rights. So try to resist those. If you can't resist and the customer's imposing on them, and it's a big customer and you can't sort of push back, you need to limit those step-in rights in terms of, you know, when can they step in? What are the step-in triggers? When are the step-out triggers? You know, what happens when they step in? What happens if there's a problem? Who's liable and all that? So, you know, it is quite a detailed dialogue you need to have if you agree step-in. Benchmarking, you know, benchmarking is ability for them to actually benchmark your services, your pricing, and if there's, you know, sort of reduced pricing, or they can get the services, you know, at a higher service level, they may have the ability to actually impose that service level or impose the lower costs or prices on you. Again, try to resist benchmarking, but if you can't, then you need to limit it and scope it, because again, that is quite a dangerous provision for a customer to have. So those are things you need to think about, how you protect the consulting in terms of the provisions. So finally, I'm going to sort of talk about data protection in consulting engagements. Now, the first thing you need to think about is identifying the roles of the contracting party. Now, the thing with data protection is, before probably the GDPR, you've probably seen provisions in consulting agreements saying the consultant and the client will comply with data protection laws. Yeah. The problem with the GDPR, that is not really it doesn't really get us there. It actually, having that provision means that if there's personal data which is processed, you'll probably be in breach of the GDPR. So that kind of simple wording no longer exists, and that's probably why you see all these data protection addendums and data protection clauses. But before you look at those, what you need to think about is, you know, what is your role as the consultant? So, you know, there's three scenarios. There's the controller-processor relationship, yeah? So that is where effectively the client is the controller and you as the consultant is the service provider. Now, if it's a controller processor relationship, that means the client's sort of responsible for determining the purpose and means of processing, and you're basically processing on their instructions. And if that's the arrangement, Article 28 of the GDPR is actually, we'll go into that, sets out in prescription what the contract should look like. So what the contractual provisions are. So Article 28 goes into detail. Well, it doesn't actually tell you what the clauses, how the clauses should be drafted, but it gives about, and I'll talk about in the next slide, it talks about what the clauses need to cover. Joint controller. So this is where basically both the customer and the consultant jointly agree the sort of the means and purpose of processing. So if it's a joint contractor relationship, Article 26 sets out the arrangement. So that's the article you need to look at. We'll talk about that in the next slide. Now, controllers in common or independent controllers, that's not expressly covered in the GDPR, but it is a scenario you need to contemplate. So this is where effectively the client is an independent controller and you as the consultant is an independent controller. As I said, GDPR contains no requirements for that, and we'll talk about how you address that in the next slides. So before we talk about sort of the clauses, how you sort of address that, the other questions you need to think about is obviously, you know, what types of personal data are involved? Are there any special categories? Any data? Who are the data subjects? If there's children, there's more protections. What are the data flows? Is it one-way, one-way, two-way? Is it onward transfers outside the UK, EA? In which case, which countries, where will be data be stored? You know, as a consultant, you need to engage other processes. Is there any automated decision making? Is there any direct marketing? Is there processing for direct marketing purposes? Or there's any other sort of specific issues revealed through sort of pre-contract due diligence or data protection impact assessment. So that is quite a bit of a aid memoir, or basically you need to, in each consulting engagement, you need to ask yourself and the client those questions, and then depending on the answers, you will need to have appropriate provisions in your contract and appropriate protections. Now, looking at the different types of clauses, we talked about controller to processor one, which will be probably one of the most common types in a consulting engagement. As I said, Article 28 sets out the sort of what the provisions look like. So I won't go through all of them, but you know, they are in Article 28, and so you will need to make sure your data protection clause or schedule sets out all the things in Article 28, and you'll get, yes, Simon mentioned, you'll have a copy of the slide, so it'll be a bit of an aid memoir, but go to Article 28 of the GDPR. That is where the detail is provided. So in terms of joint controllers, as I said, Article 26 is where you need to look at. And basically, Article 26 says that there needs to be an arrangement between the joint controllers, which actually determine their respective obligations. So in particular, what it says is, you know, what are the parties' roles and responsibilities in relation to data subjects, i.e. if a data subject makes a data subject access request, who has to respond and so forth. And then also who has the responsibility to actually provide the information required under the GDPR, under the privacy notice? Is it you, the consultant, or is it the client? Again, you need to have that agreement if it's a joint controller relationship. You need obviously sort of a designated contact point for data subjects. And then what you need to remember is that a data subject can actually ask for the essence of the arrangement. So that's not the actual consulting agreement, but they have a right to actually ask, what is the arrangement between you? So you need to make sure that you've got a redacted or a summarized version of the arrangement, that if there's a data subject access request, you can provide it to the data subject. Now, in terms of the controllers in common, as I said, there's no prescriptive clause that's set out in the GDPR, but things you need to think about is in a controller in common, there can't be a scenario where the controller can actually instruct the other controller on how to do the processing, because in that case, there'll be a controller to process a relationship. So this is effectively two independent controllers, each making decisions on their own on behalf. So if you look at the ICO data sharing code of practice, it sort of suggests what kind of clauses that need to be included. And it talks about, you know, who are the who's documenting the parties, types of data shared, you know, what the procedure is responding to data subject requests and so forth. So it's similar to, you know, joint controllers, but it is different because they are sort of independent and they make decisions. So, but again, you need to think about the arrangement. So the thing with data protection is no matter what you put in the contract, it will be determined by the facts. So if you say the arrangement is a controller to processor relationship, but it's actually not, and it's actually joint controllers, a judge or the ICO will hold you should have had provisions which is reflective of actually what happens in practice. So you can't actually contract for it. You need to look at the factual matrix, and based on the factual matrix, put the appropriate contractual provisions in place. And that's it. So I think we've got a bit of time for questions, Simon.
Yes, indeed. Normally we aim to finish at 8, which gives you 11 minutes. Alan, do you want to take a look in the chat and Q&A?
Yes, I have. We've got about half a dozen questions. So
Wow, okay.
couple of minutes for questions, Sam. So that might prove difficult because they're very interesting and quite deep questions. So I'll just and they don't batch together, so I will just feed them through to you.
Yeah, sure.
One of them was around back with when you're talking about telling porkies, and we shouldn't tell porkies, but the question was really around what kind of liabilities come to consultants where the client just doesn't misunderstands what we've been saying to them. So in those kind of verbal exchanges, they just misunderstand it, and that I could identify that question because it's something that I come across from time to time.
Yeah. Okay. I think the best way to manage that is if you feel or you have a belief that the client or customer is having a misunderstanding, you need to actually clarify that. So you're saying something and they're nodding their head, but you actually think they don't actually understand this. You need to actually you need to think about a different way of presenting that and actually getting them to actually understand what it is. So the onus is to a certain extent on you, actually.
Is it? Okay.
Well,
right.
Not well, in the sense that it's probably better for you to manage that risk rather than actually ignoring that, I think.
Okay, all right. Peter, jump in on that, if that's...
Yes, it was my question, so I just want to clarify a bit. I go into an organization and say, I will prepare you for your audit and make sure you're ready for it. And the client therefore assumes that I am a certified auditor. And then decides that I have misrepresented myself because I said I could prepare you for the audit, but I never did say I was a certified auditor. I just know the standard and can help.
Yeah, okay. So if that came to a sort of a dispute, the judge would say, what would a reasonable person expect from that? And I would, from an independent perspective, I would think, okay, even though you haven't said you're a certified auditor, you said you'll be ready. So it would be implied that, you are registered, for example. So the best way to manage that risk is, it is a risk that to expressly say, I am not a certified auditor. Clearly, they could argue, you haven't said that because you didn't want us to know that. What harm is it for you to say, I'm not a certified auditor?
Which is what I usually do.
Yeah, and you're managing the risk, so yeah.
Okay, Sam, thank you. Be careful would be my interpretation. A second question is really around the area of NDAs, and as consultants, we all get to sign quite a few NDAs, and they seem to have no time ending. So the question is, have you any views or advice on NDAs and how long they should last for?
I mean, you can contractually restrict something for an NDA to last, X number of years. If it's not, it would last in perpetuity. But the caveat is that if a certain information is not confidential because of the lapse of time, an NDA won't actually sort of change that position. Yeah. So
Okay.
Even though you sign up to something which says it lasts forever, if by the lapse of time and by factual circumstances that information is no longer actually confidential according to confidentiality law as opposed to contract, then you're okay.
Okay, all right.
Yeah.
Thank you. That helps. Thank you. On the area of operating internationally, the question has come up around what happens when I'm operating internationally. I can't be familiar with all of the local laws, regulations, and practices. I mean, what liabilities do I pick up as a consultant operating internationally, or what advice would you have around that situation?
Okay, well, I guess there's two things. Obviously, there'll be the consulting agreement, so that'll be governed by a particular jurisdiction and governing law. Yeah. Okay. Say for example, you've got a consulting agreement which is governed by English law and governed by English courts. Yeah. So you've got that, but then you're actually providing services in, say, I don't know, let's say China, yeah, China or India, yeah. So, okay, so even though the agreement's governed by English law, there may well be Chinese laws and Indian laws which apply irrespective of whether the governing law is English or is English. So that is something you need to be aware of. So my recommendation for consultants is, if you're operating in a particular jurisdiction, you need to know whether there are laws which will impact on your services. Okay.
And if I'm in a big firm, as I was once, then I can turn to my legal department, and it's quite substantial and linked around the world. If I'm not in a big firm, and I'm going into doing some business in China, is there a way that I can know? Is there an easy way?
Well, I guess you could look at what's publicly available in terms of, in terms of law. Yeah. But I don't think there's any it's just a risk of doing business, I think, in that particular jurisdiction.
Okay. All right. Okay. All right. Moving on to the next question. It's a question around what happens to consultants when the client gets taken over, or the control of the client organizational division changes. I mean, to what extent is the taking over company, the company that's doing the taking over, obligated to continue the consultancy contracts that they've got with you, even if they weren't involved with them and don't really value them anymore? What's the position there? Are they locked into
I guess a takeover, it depends on the type of takeover. So when you buy a company, you can either buy the assets of the company or the shares of the company. Yeah. So if a company is buying another company by shares, effectively the shareholding changes, but the corporate entity is still the same. So the consulting agreement will be still effectively the same. So they are bound by that consulting agreement because the entity is still there. It's just owned, or the shareholdings change, yeah. But the ultimate contracting party, the customer, will be the same in the consulting. So it's like nothing's really changed, yeah. But if they buy the assets, it depends on whether they've particularly bought that contract as part of the acquisition. So they haven't bought the shares of the company, but they've bought certain assets of that company, and it depends on whether they've actually, bought that contract.
Okay. All right. Yeah. Okay. All right.
But in most cases, as a part of a takeover, it is usually a share acquisition. So the underlying entity is still the same. So they will be legally, you've still got a legally binding contract.
And if they wanted to get out of it, like things have fundamentally changed. Is that talking back to your slides on termination?
Yeah, they would have to. Yeah. I mean, they would have to look at how they could sort of walk away. So obviously, if you had a termination for convenience clause, it makes it easier. Yeah, right. They just serve it to. But if it's a termination for breach, then they would have to prove a breach.
Right. Okay. Yes. Okay, I can see that. There probably wouldn't be a breach in most situations.
No, but I mean, the thing is, sometimes customers try to engineer a breach. To try to get out. So you need to, that's why it's really quite important to have all your obligations documented quite clearly. Because if you don't, they will say, look, you haven't performed, you're in breach, we're terminating.
Okay, that's really good advice, thank you.
Sam, if I can throw in a question of my own, because I've seen this situation so many times. All of this great advice about what I want to put in my contract is fine, but then my client says we have a standard contract as well, and here's our terms and conditions for hiring consultants. So they've got a standard contract, I've got a standard contract, and we're kind of waving paper at each other.
Yeah.
What do you do?
Yeah. So I think I touched upon that. I mean, I think that's the first thing you need to agree, but it depends on your negotiating leverage. Yeah. So if you're a small consulting and you're dealing with a big bank or a big, retail organization, your leverage is probably limited, and you probably need to use their consulting agreement. But that's not to say you need to sign up to it as is, unless they're playing really hardball and say we're not going to negotiate, in which case it's a risk for you. You need to accept that risk that you're signing up to a contract which is not protecting your interests. But if you're signing up to a customer drafted contract, you can obviously negotiate and revise that. It's not like you have to accept it as is.
It is kind of tricky if the customer is the British government, because they're not known for flexibility when they're contracting.
Yeah, I mean, I think that's a risk of doing business with the UK government. But what I've seen is the smaller consultancy in that case don't actually contract directly with the government. So they usually a subcontractor or subcontractor to another one, and you can usually get better concessions or better contract when you're a subcontractor, because the prime will take more of a risk. And
You should try working for the Chinese government.
No, thank you. I very nearly did at one stage in my career.
Okay, and Sam, the final question.
Yeah, sure.
Is around IP, and
yeah.
It's really around, can consultants practically and legally maintain ownership of all the IP in a assignment, even after they've been paid for the assignment and things have moved on?
There's a common misconception. Just because a customer pays for the IP, they don't own it. So you as a consultant, under copyright law, you as a consultant, the author or the creator of the work owns the IP. So if you don't have any provisions dealing with the assignment of IP, even though you may have been paid £1 million or 10 million quid, I don't know which customer would not have covered the IP, but maybe you're dealing with not such a astute customer. You as a consultant would own the IP. So the customer, it's up to the customer to have an express assignment of the IP. If there's no express assignment of the IP, you as the owner or you as the creator will own the IP, even though you're paid for it.
Okay, all right, this is interesting. Thank you. I've got some questions of my own. We could probably be here all evening, and Simon will throw things at me because we're reaching time.
I was going to cut you off.
The questions from the audience, and thanks to the audience for those questions.
Yeah, okay. I'm happy to stay on for a few more minutes if there's any other questions from the audience.
Well, let's do both. Let's formally wrap up, and then if people want to chat to you, then obviously we can keep the channel open and get some feedback going. I think though, over the course of the last hour and a half, I have discerned the answer to life, the universe, and everything when it comes to all of your questions. And almost all of the queries that people have got, I think the correct answer is hire a specialist lawyer to advise you. Would you agree, Sam?
Well, not necessarily. I mean, I think you obviously need to know what you need to know, and you need to know when you need to get. It's like consulting. You need to know when you need to engage a specialist. So it all depends on the type of services, the value of the services, the risk, and so forth. So yeah.
Anyway, whether or not people take my advice, I certainly hope that we get the chance to hear much more from you in the future, Sam. It's been a really interesting session. Absolutely packed my brain with thoughts there, and I'm going to have to spend some time trying to store all of that away in my long-term memory. Been great. Thank you very much. Thank you, everyone who joined us. Thanks for those people who fed in some of the questions. Apologies for some of the problems we had with Zoom, which took us by surprise at the beginning, but it has been a great session, and hopefully we'll see everybody again. So let's call it a day. We'll call the session over now, but if you want to turn your cameras and mics on and have a chat to Sam for a few minutes, that's fine. But we will, I think, turn off the recording at this moment.
Fine. Thank you all.
Sam?
Hey, Stephen.
Just a quick one, kind of lower level. You mentioned change control and impact assessments.
Yeah.
And you said to me quite an extraordinary thing that you expect to charge for doing an impact assessment. I mean, that itself becomes a kind of mini subcontract on its own. You could get into dispute about whether you have done the impact assessment correctly and charge for it correctly. I mean, all the expert work I've done, generally speaking, number one, there is very often scope in the contract for change requests and for impact assessment, but they're mostly honoured in the breach rather than the observance. Number one, I mean, actually getting a formal impact and a change request and a replanning of the project and delivery dates and costs is quite rare, actually. But number two, to actually then expect the customer to pay you to just come back with your quote of what would the change mean, because they're going to pay for the change, hopefully, if they accept it. To pay you to do the re-quote seems extraordinary to me.
Yeah, it depends on I mean, what we've seen and what we negotiate on suppliers and service providers, particularly if the impact assessment takes more than X number of hours or X number of days. So we're saying, if the impact assessment is, it's not going to take more than 2 days of man time or something. If it's, if it's a huge change, it's going to take 5-10 days of actually scoping it out, think your dependencies, then yeah, you have the ability to charge. So there is a threshold where below that you don't have the ability to charge, but above that you do. So I'm not saying all, but I think there needs to be some kind of threshold.
It just raises a question of who's saying it should take 5 days? Where is the performance indicators of whether you're doing your impact assessment correctly and to a right standard of due diligence and competency?
Yeah, but if the customer's already agreed to that, I think at that stage they've accepted the risk, that they're basically accepted the risk that, if the service provider says it's going to take more than X number of hours, X number, they'll pay for it.
Sounds like a bit of an open-ended checkbook for, as soon as I think of a change, well, you're going to actually charge me to even talk to me about the change,
Yeah, well, most, as I said, most service providers most customers would not accept that. But if you've got a large service provider who's got a lot of negotiating leverage, then you can. It again depends.
As you say, it depends on the relative strengths, doesn't it? And the size and the length of the project and complexity as well, obviously. Yeah. Okay, that was it really. Yeah, thanks.
Yeah. Okay. Any other questions? Alan, you had a few.
Well, I was wondering, Sam, around the area of boutique consultancies, because I had the luxury of the legal departments of the big four consultancies for quite a while, but when you become a boutique consultancy, you kind of miss that, and I was wondering how the legal industry is kind of structured. Is it possible to get those kinds of services from people like yourself in a fairly easy way?
In terms of what? Sorry.
Well, if you're operating in a big four consultancy, these kinds of legal questions come up quite a lot, and they often come up as a kind of I just need to check this out with legal just to make sure there isn't a problem, and much of the time you find there isn't a problem.
Yeah.
But that is important to know that there isn't a problem, and but once you move into a boutique consultancy, you haven't got
the sort of in-house legal resource, yeah.
And as a consultant, I've never kind of in a larger consultancy dealt with the kind of legal industry, because that gets kind of brokered through the legal
the in-house legal team. Okay.
I'm wondering how the legal industry is kind of structured, and whether you've got any experiences of it supporting boutique consultancies.
Yeah, it does. Yeah, I mean,
outsourced way.
Yeah, I mean, we support the individual one-man traders to the big multinationals. I mean, yeah, obviously, there is a fee to be paid. Like all things, we're a very large law firm. Our hourly rates are pretty expensive. If you compare that to a sort of a mid-sized or a small law firm.
Okay.
So yeah, there's a variety of law firms that you can reach out to, and different hourly rates and stuff, just like consultancies.
Yes. Okay. All right.
Yeah, but yeah, I mean, yeah,
I'll look into that.
I can't, if you want to approach any lawyer in a law firm, they've got their details on the website. All you have to do is give them a call, send them an email, and say, this is my particular issue. Can you give me a quote? And we give you a quote. And it's up to you whether you decide to accept that or not.
Okay. All right.
Yeah. Or the first thing you could probably ask is, can you tell me your hourly rate? I can tell you my hourly rate. It's nearly £1,000 an hour. So you may say, okay, thank you, but no thanks, which is fine.
Certainly, I'll ask my questions quickly.
Can I say that there are one or two kind of lone lawyers that specialize in IT? Well, there used to be more, but I think that a lot of them are now retired or have joined bigger firms or amalgamated, that would charge, that are boutique law firms that deal with consultants and IT firms, and probably don't charge Sam's rates. Not that Sam isn't worth every penny, of course, but I mean, they're not part of a huge law firm, so you're getting a much more tailored individual rate. I won't mention any names, but I mean,
no, that's
BCS is probably, people in the BCS know them as well.
Okay, all right, that's good to know. That's why. Yes. Okay. Thanks.
I think maybe I should also wave a flag, particularly in the medium to large consultancies. And I was talking about the legal departments. My last posting at KPMG for 2 or 3 years was to head up the quality and risk management team, which is the team responsible for basically policing everything that you do if you're a consultant in the firm, and the other big firms have the same kind of setup. So my team spent all their time checking contracts and checking deliverables and making sure you've got all of the limitations of liability in place and making sure you've done all of your client checks and looked out for conflicts of interest and all that kind of thing. So there is this kind of halfway house to calling in the heavyweight lawyers that typically you'd find internal people whose role it is to be very much the kind of internal advisors on all matters to do with the contract and conduct of the engagement.
Yeah. I mean, we act for quite a few of the sort of large consulting things, but, they've obviously got in-house legal teams and they're outsourced to us when, it is a specialized area, it's really high value, or they just haven't got the bandwidth. So, yeah. But most businesses have, larger businesses have got in-house lawyers, so they handle all the business as usual stuff.
Okay. That's good to know. Thank you.
Yeah.
I when I was in the Big Four, I used to, I was forever making smarty pants comments about the legal team and the risk team, and there always seemed to be, you needed to go to them for things. But now that I'm away from it, I actually miss them. It was so easy at the time to just pick up the phone and ask them.
Yeah.
And now I kind of feel I'm kind of out in the field doing these things, and I do wonder how much liability I do end up with that I don't know about.
Yeah, but again, it depends on the type of services you're doing, and with liability, effectively for a client to sue, they have to suffer damages and got to prove the damages. Yeah, it's not just about if you haven't provided the services, that doesn't necessarily mean that they can sue you. They need to actually prove a loss.
Yes, that's true. That is true.
Yeah. So yeah.
Right, feel reassured. Are there any other questions, or?
We've still got 18 participants. I don't know if the people logged off or this.
Oh, can I dive in again?
Yeah, go on, Stephen. You know, you could ask me these questions anytime, Stephen.
No, it's more.
As long as he pays the fee.
But actually, it's just from what something that Simon said.
Yeah.
That having people that are there to check compliance of various things before at stages of when what you didn't mention at all, I think, in your presentation is where do formal project management methodologies fit into this? Because and what legal force do they have? Because many of them have assigned on big projects have assigned people like requirements authority, QA authority, which have a quasi-legal compliance role within the project, but don't necessarily, as far as I'm aware, require those people to have legal training or legal knowledge, and not even to necessarily take legal advice in the sort of sense that Alan was saying when they're doing their formal stuff within the project management methodology. I don't know what if you've got a comment about the role of mentioning within the contract that you or your team or the client's team, because it puts responsibilities on the client as well. Most methodologies, where do they fit in to your legal issues that you've covered?
Yeah, so in terms of those sort of QA review bodies or whatever, they'll be part of the governance sort of schedule. So it'll be really part of the governance mechanism, the meetings and the frequency and what the outputs and outcomes are. So from a contractual perspective, it would be more, if the meetings weren't held or if a particular output wasn't delivered as a meeting, as a result. So yeah.
And the answer is always, it depends what it says in the contract you signed. If the contract makes things mandatory and specifies how they should be done, then you'd be in breach of contract if you didn't do it that way. Whereas if it's kind of a fuzzy thing about applying best practices in project management, you could probably argue your way out of almost anything. So it very much depends on the contract.
And most customers actually, the consultants will say we'll be applying this kind of methodology approach. They don't know whether you're applying that or not. So as long as you apply something, really.
It has to be said that in all the litigation I've been involved with, it is rare that anyone gets around to alleging in proceedings that the mere fact of not following the methodology. I mean, there's a lot of hand waving and they pile it in, but it rarely amounts to a material breach of the contract, because you say, well, if I had done it, if I hadn't done it, how does it actually affect the outcome?
I agree.
The real business of the contract, never forget, is I pay you some money and you deliver me something that's supposed to work. I mean, all the rest is a means to that end. Correct. You can't say it's a material breach just because I haven't followed the means quite as I promised. I agree. I would follow it.
Yeah. Okay.
On the other hand, if you haven't tested your deliverable adequately, then that probably could be a material breach.
Could do a whole hour's presentation on that, but maybe I will one day. Well, I have done. Just read my papers.
I feel my dinner's calling, guys.
Yeah. Okay. Good. Okay.
Sam, that was fantastic. Thank you very much indeed.
No, you're welcome. Okay. Good.
Well, enjoyed that a lot. Thank you.
Okay. Cool. Well, have a good evening, and yeah, I'll catch up with you some other time. Hopefully, we can meet in person.
Absolutely. Look forward to it.
Yeah. Cool. Okay. Cool. Okay. Catch you guys later. Okay. Thanks. Okay. Cool. Bye. Bye.
Thanks, Simon.
Bye.